Yeah, well, let's start raising my rates.
All right, ladies and gentlemen, we'll begin this panel. Our moderator today is William Chip Carter, who teaches human rights law at the law school and has published in some of the best journals in the country, and he was instrumental in putting this panel together, and so I'll turn the floor over to him.
Good afternoon, everyone. One of the good things about my job is that people applaud when you haven't actually done anything. Like at the end of the semester, the students all applaud for you. Nonetheless, I am very pleased to be here to introduce you to our last and, at least in my opinion, what will be our best panel of the day, discussing adjudicating torture in American courts. Let me just briefly introduce our speakers and then get out of the way so that we have time for them to dialogue with you, as well as leaving as much time as we can for you to ask questions. John Hudson, who is sitting immediately behind me here, was appointed Dean and President of the Franklin Pierce Law Center in July 2000. Dean Hudson earned his J.D. from the University of Minnesota, and upon his admission to the State Bar of Michigan, began a 28-year career in the Navy. And as a result of that lengthy service, he was promoted to the rank of Rear Admiral in May 1997. And he assumed his duties as Judge Advocate General in that same year. As the Navy JAG, he was the senior uniformed legal officer to the Secretary of the Navy and the Chief of Naval Operations. Dean Hudson is an expert in all areas of military law and is also a nationally noted commentator on matters relating to the military, human rights, and the rule of law. He's also the author of numerous opinion pieces and legal articles that have appeared in well-respected journals. Alisa Massimino, who is sitting to my right, is the Washington Director of Human Rights First, formerly known as the Lawyers Committee for Human Rights, and she can tell you a very lengthy story about how the name change came about if you want. Ms. Massimino is the organization's chief advocacy strategist, and she's an expert on a range of international human rights issues. She frequently testifies before the U.S. Congress and has written extensively for legal and popular publications on human rights issues. She is Human Rights First point of contact with U.S. government leaders, international diplomats, and human rights opinion leaders and decision makers. She was previously a litigation associate at Hogan and Hudson, and if you overlapped with Chief Justice Roberts, you might be able to tell us what his thinking might be on some of these issues today, if you dare. Okay. She has been the director of Human Rights First D.C. office since 1997. Our third panelist for the day, Julian, is an associate professor of law at Hofstra University, and I'm given to understand that this is the second tour of duty he has done for us today, as has Elisa, so we thank you for your service today. Julian's main research interest is in the area of the intersection of international and domestic law, and has published numerous articles regarding foreign relations in a number of journals, including the Minnesota Law Review, North Carolina Law Review, and the Virginia Journal of International Law. His most recent article, Beyond Formalism in Foreign Affairs, A Functional Approach to the Alien Tort Claims Act Statute, was published in the 2004 issue of the Supreme Court Review. Prior to joining the Hofstra faculty, Professor Koo served as law clerk to Judge Jerry Smith of the U.S. Court of Appeals for the Fifth Circuit and was also an Olin Fellow and lecturer in law at the University of Virginia Law School. So with that, I will turn this over to the panelists to give us their views on the issue of adjudicating torture in American courts.
Oh, good.
Good afternoon. It's a real pleasure to be here. I can only conclude, since both of my fellow panelists have spoken before, and this was introduced as being the best panel, it must clearly... and I'm also, as I said to Chip a little bit earlier, that I was glad to see some of you actually coming back in after you had all streamed back out at the end of what I know has been a long day. So I appreciate your presence and attention very much. My remarks are going to be probably as not illegal, unlegal, non-legal, as you may have heard since you've been here. What I've discovered since I've gotten older and perhaps wiser, that remains to be seen. I've been a lawyer since 1972, and the longer I'm a lawyer, the more I believe that none of this really makes any difference. I used to think that it was all the law, and that was the only thing that really mattered, and we'd argue these little points of esoteric detail, and I've come to realize that in the end, if people of ill will or unwisdom or malevolence are working on some of these issues, it isn't going to make any difference, no matter what the laws say or how we parse the various treaties and statutes and so forth. So my remarks today are entitled, "Why Not the Courts?" And why not the courts indeed? I think why not the courts because they are not the most capable of dealing with these tremendously important issues for two reasons. One is they don't always get the issues, and the courts can only deal with that which is brought to them. So that's one reason for us not to rely on the courts, because the courts aren't going to face the most important issues oftentimes. And the other is that for those cases, those issues that do finally come to the courts, they are bound by the law. And that I think the more important considerations, I've come to believe, than just the law are other things, social, moral, practical, and so forth, and things that we'll talk about. One of the, perhaps the only, immutable rule of international law and domestic relations is that nation states will always, without fail, do what they perceive to be in their self-interest. They will always do what they think is in their self-interest. Now, they may be wrong about what's in their self-interest. They may have misjudged it. They may not be very wise. They may be thinking short-term rather than long-term over the horizon. But they will always do what they think is in their self-interest. And that self-interest is generally, but not always, reflected in the laws and treaties that they have to deal with. I would submit that since January of 2002, at least, we've largely ignored those laws and treaties. Thus, my thesis that a lot of that just doesn't make any difference. I had an epiphany, I guess, over the course of the last couple of years. Sort of to my surprise, I've come to realize and to believe that laws are less important than I thought they were, and that lawyers as a group and just citizens as a larger group are much more important than I thought they were. The nation, I believe, is in sort of a legal malaise right now. We are relying altogether too much on the courts. We're not thinking for ourselves. We're not speaking out generally about the things that we think are important. We're not holding our public institutions and our public officials to the high standard that I think we have to in order for us to ultimately win the war on terror. The United States is the strongest nation on earth, not because of our military might. It's not because of the essential island nature of our geography. It's not because of our economy. The United States is now, and has been over the years, certainly since World War II, the strongest nation because of what it is we stand for, because of the mission that we have as a country, and because of the mission that the armed forces have, that they enjoy. You know, over 28 years in the Navy, I really came to believe that and to understand it. That's what gives us our strength. Our enemies have only one weapon in their arsenal, and that's terror. And that weapon isn't aimed so much at, I believe, at human life, or even our will to win, or our will to fight. That weapon is aimed at bringing us down to their level, to taking away our greatest weapon, which is our mission, what we stand for, what the United States represents and has represented for generations now on the world scene. You take that away from us, and you've emasculated us. Then all we've got are bombs. We can just kill people and break things, and it doesn't make any difference. We don't stand for anything. So that the enemy will have won if they can bring us down to their level, and that's their goal. That's what they're trying to do. And guess what, ladies and gentlemen? They're doing it. They're winning. They're winning. How many of them can we kill? How many of them can we torture and maim? They're going to beat us unless we right the ship of state and get back onto the high road. And if we just let the courts deal with all of this, and I'm not maligning the courts at all. The courts, in fact, to the extent the courts have had the opportunity to deal with these things, they've, for the most part, I think, done a pretty good job about it. But, you know, nature abhors a vacuum. The courts will fill the vacuum. The courts have always been, and should be, largely deferential to the military in questions of military policy, because they understand, the courts understand, that they're not really adequately equipped to deal with the issues. So they defer to the military, except in the most egregious and outrageous cases. But they're limited to the law. I think we've seen what can happen to what we thought was the law. You know, the Geneva Conventions. You know, we did not enact the Geneva Conventions in the wake of World War II and push for their universal acceptance. The United States didn't want that because we felt it was necessary to protect our enemies from us. We wanted the Geneva Conventions to be customary law for every country to abide by them to protect us from the enemy. We thought. You know, the United States, since World War II, has been more forward deployed in every way in which you can consider deployment. Numbers of deployments, duration of deployments, locations of deployments, numbers of troops deployed. The United States is more forward deployed than all other nations combined. The Geneva Conventions are there to protect us. What a novel idea. Unfortunately, the law provides the floor. It doesn't provide the ceiling. It's a bare minimum, and sometimes we're able to dig below the floor and actually get into the basement. But it's certainly not the aspiration of the United States. So the courts deal with the law. Now, I won't presume to talk to you about morality. That's, we've all got our own standards, I suppose. We all derive those standards from a variety of sources, and my sources are probably completely different than your sources, unless we happen to be brothers and sisters somewhere along the line, because I get a lot of it from my parents. So I'll let you deal with what you think is moral and whether you think what we've been doing is right in the sense of morality. But let's look at it from a couple other points of view. Let's look at it from the point of view of diplomacy, for example. It is going to become increasingly difficult for the United States to gain coalition partners to fight wars in the future with partners, which we all agree we need, if those partners can't trust the United States to comply with international law. If the United States says the President of the United States, in his capacity as the Commander-in-Chief, is above all laws, foreign and domestic, which was not the oath that I took every time I was promoted. I don't remember it that way, but I don't think the President should remember it that way. Then they can't trust us to behave ourselves when we're fighting wars. So that it's not good for us diplomatically. It's not good for us in the sense that we can talk about each of these treaties on its own merits. The International Criminal Court, Kyoto, landmines, the law of the sea. This is just another one that we're not complying with or agreeing to, and it doesn't help us. Look at it from the military point of view. The pictures out of Abu Ghraib are recruiting posters for the enemy. They embolden the enemy. They make war fighting even worse now and in the future. It's not good for us militarily. You look at it from a practical point of view. Torture doesn't work. All the literature, all the experts will tell you torture doesn't work. What works is causing the enemy to forget or not focus on the fact that you're enemies, bringing them to some extent around to your side, which happens to take a little bit of time or a lot of time. It takes some talent, it takes some patience, but then you end up with intelligence that you can actually use. You haven't just beaten the snot out of them, and they told you anything in order to make you stop the pain. So that if we leave it to the courts, first of all, they're not going to get the cases, and secondly, when they deal with the cases, they're going to have to deal with them without paying attention to morality, to diplomacy, to the needs of the military, or to the practicality of the issues. I can tell you that we could stop this. It could be stopped in no time. If somebody in authority, let me think of, I can see if I can think of somebody who might be in authority. Oh yeah, Commander-in-Chief. Let's say him, for example, said, not in a press conference or in an offhanded manner or through his Scott McClellan, his press guy. If the President of the United States said in military order number, I think it would be 3 now, that the United States does not condone torture, cruel, inhuman, or degrading treatment in any manner, shape, or form, and that the first general in the chain of command in which it happens again will be relieved for cause that day and investigated for possible court-martial charges for dereliction of duty, orders violations, any one of a number of different things. if it was absolutely equivocal, we could stop it. The chain of, thank you. That's what you're there for. Oh, good. Yeah. I got to fill 5 more minutes. The great strength of the military is the result of the chain of command. Without the chain of command, the military will not work. It will devolve to chaos, utter disrepair. We don't want our soldiers, sailors, Marines, and airmen to have to second guess any orders. We don't want them to think about the orders they're given. What we want is for them to follow their orders mindlessly. Just do it. Don't think about it, just do it. But for them to do that requires accountability up the chain of command. The orders come down the chain of command like a rock. Everybody knows. Lindy England didn't have to talk to Donald Rumsfeld or Alberto Gonzalez to know what it was they were thinking. She knew because the generals knew, so the colonels knew, so the majors knew, so the captains knew, so the sergeants knew, and Lindy England knew. That's the way we want it to work. It doesn't have to be confusing. It shouldn't be confusing. It has to be crystal clear. That's the way we want it to work. But the quid pro quo for that may be the closest I get to a legal statement here. The quid pro quo for that is accountability up the chain of command. The people giving the orders need to know that they will be held accountable for their failure to offer orders that are legal, or right, or moral, or diplomatic, or practical, or consistent with the needs of the military. And if they fail to do that, they're going to get in some sort of trouble. What we have failed to do as a nation up to now is engage in any sort of accountability. We've prosecuted a few bad apples, and they are bad apples to be sure. They should be prosecuted. But there's so much more left to be done. We have a systemic problem that we have simply failed to address. It's not a legal problem. It may be a recruiting problem. It may be a training problem. It may be a supervision problem. It may be a leadership problem. You know, there are lots of potential problems there. But we don't have the moral courage or wisdom to deal with it. And what will happen as a result of that, as sure as I'm standing here with 1 minute and 30 seconds left to go, is that this is going to happen again. It won't be Abu Ghraib. Probably won't even be a prison. It may be tailhook. It may be the drug problems on the USS Ranger. But we will look back on it and we will say it's the same genesis as what happened at Abu Ghraib. The chain of command didn't work. We issued fuzzy, unclear, malevolent, immoral direction to our subordinates, and then we let them take the heat for it. Lindy England got what she deserved in some respects. But she didn't get what she deserved in a lot of respects. She didn't get the leadership. She didn't get the guidance. She wasn't sent out on a mission that she could be proud of and feel good about. So she got what she deserved, but she didn't get what she deserved either as a United States soldier. And if we let the blame lay at her feet and dust ourselves off and say, by George, we took care of that problem. We court-martialed 6 of them. It's going to happen again. And it's not a legal issue. It's not an issue the courts can deal with. It's an issue for us. It's an issue for the United States Congress, which is up until 2 days ago taking a pass. Thank you all.
So I guess we switch orders.
Hey, well, I want to thank everyone for this time not just for listening to me, for more likely for listening to me again, and for also I want to give a special thanks to any law students who are here, because I can recall not that long ago when I was a law student that if I wanted to spend my Friday afternoon at around 4 o'clock listening to some obscure law professor talk about the law, it seems very unlikely that I would have made the effort to come here. So I really do appreciate you guys sticking around. I have a somewhat different take from the last speaker. And actually, although I don't disagree a whole lot, I do want to focus. I do think actually that courts are getting involved in overseeing U.S. government policies with respect to detainees, in particular the policies governing the interrogation of detainees. And so what I do think so the question for me that I'd like to address is what is the proper role of civilian courts, federal courts, in overseeing the conduct of the military in interrogating detainees? It's a very specific, sort of narrow, and I'm going to indulge myself and do a little law discussion. And I want to focus on the case of Ali versus Rumsfeld, which is a case brought by the ACLU and Human Rights First against Secretary of Defense Rumsfeld, alleging that his participation in the formulation and administration of interrogation policies violates a variety of laws, instead seeking damages against Secretary Rumsfeld and seeking to hold him liable for abuses that might have occurred or that have alleged to have occurred in the prosecution of the war on terrorism and the interrogation of detainees. Okay, so the issue for me is what is the proper role of courts? And my view is not that there is no role for courts. I do think there is a role for courts, unlike Professor Hudson, Dean Hudson, in reviewing the conduct of the war on terrorism. But I do think this role is somewhat limited. And so I want to focus on a particular limitation that I think is an important limitation, but one that is not necessarily widely accepted, at least among international law scholars. I think that the federal courts, although they do have a role in administering and overseeing the conduct of the U.S. military and testing whether or not their conduct meets constitutional, statutory, and treaty standards embodied in constitutional, statutory, or treaty law, I do not think the federal courts can override or reverse the executive branch's interpretation of customary international law. So let me explain first why I think the question of whether federal courts can enforce customary international law against the U.S. executive branch is important. And then I'll discuss what I believe is the proper role of the president in controlling, interpreting, and applying customary international law. And I'll argue the president holds almost complete control over the interpretation of customary international law on behalf of the United States, subject to review not by the courts but by Congress. Finally, I'll review some aspects of the publicly released documents and the allegations in the Ali v. Rumsfeld lawsuits, and sort of analyze a little bit how this might affect the outcome of at least some of the claims advanced in that lawsuit. Okay, so why is customary international law important? And I approach this not from sort of abstract perspective, from the perspective of if you were an attorney who is either going to sue Secretary Rumsfeld or going to defend Secretary Rumsfeld, why should you, in domestic court, do you need to care about customary international law? I think you do. In particular, the reason you do is because, as with the lawsuit against Secretary Rumsfeld, it's brought, at least in part, under the Alien Tort Statute, which a lot of you are familiar with, which allows individual aliens to sue for violations, for torts and violations of the law of nations, which is historically considered customary international law and of treaties of the United States. Okay? And so the lawsuit brought against Secretary Rumsfeld does allege that Secretary Rumsfeld approved policies that violated constitutional law, constitutional law, treaty law, and customary international law. Now, I don't have any sort of problem, and here's where I think federal courts do have a role. I do think that it is entirely appropriate for federal courts to review whether or not the executive branch's conduct is consistent with constitutional law, the prohibitions embodied in the Fifth and Eighth Amendments. I similarly think that they do have a role in reviewing the question of whether or not their conduct violates treaty claims, although that's a question that's a little harder depending on the type of treaty that's being sought to be enforced. Okay? But I think that customary international law is different. And it's also important because in many ways customary international law provides the Ali plaintiffs with the most attractive legal theory for holding Secretary Rumsfeld liable. Okay? Many of the claims and allegations will be made not under violations of the Eighth Amendment, but claims that they violate broad conception of customary international law that are widely accepted in the world community. So the customary international law of war, the customary international law of human rights as embodied in documents such as the Universal Declaration on Human Rights. I think that this is going to be an important element of this lawsuit, and it raises the question, which I think has never been resolved definitively by the U.S. courts, is whether a federal court could overrule the executive branch's interpretation of customary international law. And my argument is that they can't. Okay. Now, what are my arguments? Well, I have three arguments as to why the executive branch has primary control over customary international law. First, it's structural. Okay, the executive branch, I think there's no serious disagreement that they're the chief foreign policy organ, and it is his power, it is the president's power to conduct foreign relations, and the courts will, generally speaking, defer to the president's determinations as to what is the foreign relations of the United States. Okay. In particular, one element of customary international law is state practice, and to the extent that state practice is part of customary international law, the executive branch is the primary controller of state practice on behalf of the United States. Now, my view is that the executive branch generally interprets, administers, and controls customary international law, but that in almost all circumstances, Congress could override his interpretation of customary international law. But absent congressional intervention, that is, I think the power is held by the executive branch. This power is recognized in, I think, the two leading cases on customary international law by the U.S. Supreme Court, the Pequite-Habana and Sosa versus Alvarez-Machine. The Pequite-Habana explicitly, which is a case involving the customary international law of war, explicitly held that the executive branch, that customary international law is part of the United States law, as long as it doesn't subject to a controlling executive act. Right? This language has been widely sort of fought over, but I think that at least provides a strong precedential support for the otherwise sort of sensible structural reading that the executive branch generally administers and interprets customary international law. Even in Sosa versus Alvarez-Machine, which was decided only 2 years ago, as by the U.S. Supreme Court, the Supreme Court did not address this issue, but did drop a footnote arguing that whatever the executive branch's statement of what the foreign policy of the United States required would be given substantial deference by the courts. Now, this doesn't necessarily reflect absolute deference, but I think it does reflect the court's recognition that this is a question which the executive branch has a lot to say about. And I also point actually to issues of sovereign immunity, which historically have been something that courts have given absolute deference to the executive branch about prior to the codification of principles of foreign sovereign immunity, which is a form of customary international law. The questions of sovereign immunity were largely governed by executive branch determinations, and it wasn't until Congress overruled or changed executive branch determinations through statute that courts began independently interpreting the standards for foreign sovereign immunity. Finally, I just think it kind of makes sense. If customary international law is something that's driven by a variety of factors, including state practice, wouldn't it make sense to have the branch that's generally in charge of the foreign policy organs of the United States and administering the foreign policy organs of the United States to be involved in controlling the interpretation of it? In other words, to the extent that you want to have a unified view on behalf of the United States of what customary international law is, wouldn't it make sense to have the branch that is most actively engaged in administering and using customary international law in its day-to-day activities, why wouldn't it make sense to have that branch be the one that actually controls the interpretation of customary international law? Okay. Well, how would that apply to this case? Okay. Well, my view is that if you look at the way that Secretary Rumsfeld, at least as alleged in the complaint, and again, the facts here are very murky, I think that if you look at at least based on the allegations of Secretary Rumsfeld's approval of certain detainee interrogation policies, not looking at his allegations about his failure to stop abuse, which I think is a harder case. But if you just look at the actual process by which the Defense Department went through the process of trying to determine what was legal, what interrogation policies were legal under the various statutes. And I'm not talking about the torture memos now. I'm talking about the Defense Department's literally going through specific interrogation policies. I think it would be, if the executive branch has the authority to definitively interpret customary international law on behalf of the United States, I don't think a federal court could second-guess that interpretation. Okay? And in this case, there's evidence to suggest Secretary Rumsfeld did seek legal advice. He was advised by DOJ that customary international law did not bind him. But that's correct in a way, but it doesn't mean it doesn't matter, right? They did make interpretations and try to figure out whether the interrogation policies they actually adopted would be considered by other countries as violating customary international law, right? It is the duty of the United States to, as with respect to foreign affairs, to take a position on whether something is, in their view, a violation or consistent with customary international law. Okay? There's some evidence to suggest the Defense Department made such an effort to determine whether or not its view and identify where it departed from other countries' views of what customary international law requires. Okay? And so by analyzing specific techniques and trying to determine whether or not they would be consistent with other countries' views, and then deciding that's not the way we're going to do it, that's the way we believe. We don't believe customary international law requires as much. That strikes me as at least a plausible case that they've interpreted customary international law to not prohibit the actions they adopted. Okay. So now, in the end of the day, the Defense Department Working Group made very broad recommendations, and actually, interestingly, Secretary Rumsfeld actually rejected a number of the most coercive techniques. Now, maybe you say he did that for the wrong reasons, but he did reject approval for a lot of the most coercive techniques. And he limited a number of the other techniques that might be seen as violations of customary international law, including isolation, to situations where his personal approval had been provided. Right. So I guess the caricature of Secretary Rumsfeld and the Defense Department process is being simply giving carte blanche to broad sort of abuses, at least isn't true, at least with respect to this the process by which he went through and he and the Defense Department developed these policies. Now, I do think that, as I stated before earlier, obviously there were huge failures in implementing these policies down, as Dean Hudson suggested, in the chain of command. But in the mere approval of policies, right, and the analysis of whether or not they violate customary international law, I think that with respect to just that one of those particular acts, which are the acts, by the way, that are most likely Secretary Rumsfeld is most closely tied to, the specific documents he signed, right? So just to give you an example, he agreed that in some cases environmental manipulation, right, might be a permissible coercive interrogation policy, but it was defined as altering the environment to create moderate discomfort. Conditions would not be such that they would injure detainee. Okay. Now again, it looks like it's very much the case that they didn't actually follow this policy, but with respect to the policies he actually said he was approving, if he finds that environmental manipulation is not a violation of customary international law, at least as it's defined here, I don't think it would be the right role for the federal courts to reverse that determination. Now, would the court interpret, if the court interpreted constitutional law or federal statutory law to prohibit such a practice, that would be a different case. Customary international law its status in U.S. law is very different from these other two types of law, and because the executive branch is traditionally controlled, at least as I argue, the interpretation of customary international law, I think it makes sense to separate that out, to say, okay, courts have a proper role in reviewing U.S. Policies in the interrogation of detainees and making sure they live up to the constitutional treaty and statutory standards that they're obligated to follow, but that to put customary international law aside. I would just point out that no court has ever found the executive branch liable for a violation of customary national law. And I think it's unlikely, and it's unlikely that it will happen in the near future. So the question is not whether there is a role for civilian courts in reviewing the legality of U.S. detainee interrogation policies. It's just a question of whether courts should, at least for me, I think courts should, but they should not wield a customary international law to override the President's interpretation or application of those principles on matters within his constitutional authority. Thanks.
Thanks. I'm not going to talk for very long because I feel like we haven't had very much time for questions today. And so I think there are some people who have had questions throughout the day that they haven't been able to ask, I get the sense, and I would like us to be able to do that before we leave. But I do want to just say a few things in response to Julian, and then raise a couple of other questions that we haven't actually put on the table yet, but not address them in any great depth. I'm not an expert on customary international law, but I do have to say, Julian, that it strikes me as just a little circular. I did study philosophy for a long time, and it does. Your argument strikes me as a little bit circular, that the executive branch gets to trump the other branches in saying what customary international law is, and that the courts don't have a role. I don't know how this lawsuit is going to work out, and I apologize I can't speak in great detail about it because I'm on the other side of a litigation firewall in my own organization. I don't know a lot about the details of the arguments that we're making against the Secretary of Defense. But if you want to read more about it, you can go to our website, you can read the complaint, and you can read the details of the abuses that were suffered by the 8 men who are our clients there. But usually the courts don't like it when you make that argument to them, and hopefully we'll get a judge with a different view. But I would urge you to look at that. I wanted to put a couple of issues on the table about this question about torture in the courts, and bring it back to the goal of the jurisprudence on torture, the convention and the statutes of deterrence and accountability. I mean, the goal of the treaty to prevent torture, which I talked about a little bit before, and the role of prosecution, first of all, in reaching that accountability and creating some deterrence. We have failed in this country to make prosecution for torture a credible threat to help deter. And you've heard throughout the day a little bit about 18 U.S. Code Section 2340, which is the torture statute, the anti-torture statute, which was one of the first things I was working on when I started working for what was then the Lawyers Committee for Human Rights, trying to get the treaty ratified, and the stumbling block was to get a statute passed that criminalized torture. And it took several years to do it because the people who kept offering it as a piece of legislation in Congress kept attaching the death penalty to it. So all the groups who were pushing for it ended up having to oppose it every time. We finally got it passed without the death penalty and had a big party, and then 6 months later, when nobody was paying attention, the death penalty was put back in. So it's a capital crime. But the piece that we talked about, and Mike Newton referred to it, about the phrase that it criminalizes only conduct outside the United States, was another problem. Of course, it wasn't the problem that we thought we had, that we have now with that language. But back then, some of us believed that it was a little crazy to say torture is illegal when it's outside the United States. And what does that mean about torture when it's committed inside the United States? The argument was that, well, all the conduct that would constitute torture is already criminalized, so it would be overkill to make it apply inside the United States. And there's some, it was right around that time when a Haitian immigrant in New York City, Admiral, was tortured by police officers, and everyone called it torture, and the press knew it was torture, and everybody called it as they saw it, but the perpetrators of that crime were not charged with torture. They were charged with sexual assault and other crimes, and eventually civil rights violations, which have a very different burden of proof. And so we launched a somewhat quixotic campaign to remove those 4 words from the torture statute outside the United States. That didn't get anywhere. Mike Newton earlier today pointed out the sort of Alice in Wonderland place that takes us, where if you combine that with the military MIJA, I forget what it stands for now, Jurisdiction Act, you have every place is inside the United States for the purposes of the torture statute, but outside for other purposes. So you have this strange situation where the torture statute doesn't seem to apply anywhere, any real place, any geography. So I think that the courts ought to have a role in adjudicating guilt or innocence under Section 2340, but no prosecution's ever been brought for inside or outside, however you want to slice it. There was one case, and Andre may know a little bit about this and could speak to it in the question period. Anderson Kohatsu, who was involved in torture, I believe, of a person who became a U.S. citizen and was coming to the United States, and the Justice Department had decided it wanted to exercise its authority under this provision. But it was decided in consultation with the State Department that he was coming on a diplomatic visa that would have made it difficult to prosecute him. So having these kinds of prosecutions, of course, presumes that there's a U.S. attorney somewhere who's willing to do this and that actually knows about this provision of the law, which most of them don't. We tried to get a page put into the U.S. Attorney's Manual that spelled out this great new law that was at their disposal, but we didn't succeed. So I'm not holding my breath on that one. Another form of accountability, a few years ago, there were a bunch of members of Congress, Republicans in the House, who were shocked that there were foreign torturers living in the United States. We must do something about this. And their solution was, we should deport them. They apparently hadn't heard of the statute either. And some of them were kind of surprised when I asked them why they were so soft on crime. And so it was an opportunity to educate them a little bit about Section 2340. Those people belong in the dock. Telling them they have to sell their villa in Palm Beach and buy one in Costa Rica or Belize is not exactly accountability. Just a couple words about the Alien Tort Statute. I view it as a backstop, a kind of, another sort of poor man's accountability to help reinforce through the goal of deterrence, preventing torture. It at least provides some possibility of a kind of a remedy, however impoverished, for people who have been wronged. And I think it's an important one to preserve. There may be, I think that there will be a kind of legislative assault on the use of the Alien Tort Claims Act in this way during this Congress, actually. So it'll be an important thing for you to keep your eye on. So those are just the kind of a few ideas about accountability and the role of the courts, whether they're in deportation proceedings and criminal proceedings or civil proceedings to the Alien Tort Statute. And I promised that I was going to stop early so we could take questions, including questions that may come up based on other panels. So I'm going to stop now and let Chip call on people.
Okay, questions for any of the panelists, and please remember to wait for the microphone to come around to you.
Thank you. I gave dear Hudson a piece of paper which I photocopied from a recent Washington Post editorial page. It's a letter to Senator McCain from an individual who purports to be a U.S. Army officer. You take it at face value. I have no evidence that he is or is not. I'd appreciate it if you could perhaps describe the letter and give us your reaction to it, particularly in light of the observations that you made earlier, and if you have any suspicions on what may be the next steps in the life of this Army officer?
The officer referred to is Captain Ian Fishback, who has been in the news quite a bit recently. In fact, I've talked with him. And the letter is essentially a plea for Senator McCain to do what Senator McCain did ultimately, which is to introduce and get his colleagues to pass an amendment to the DoD spending bill, which would incorporate the Army Field Manual into law in order to clarify what the rules are. And Fishback says that he was unclear about the rules with regard to the application of the Geneva Conventions and what the rules were with regard to treatment of detainees. And he tried to get clarification and was unable to do that successfully. He still was confused. Which sounds a little odd when you first look at it. You think, gee, here's a bright guy, United States Military Academy graduate. He ought to, he was required to take courses in these things. He should understand it. He should, and particularly should understand it if he made any effort to try to understand it, you know. But I can tell you from my own experience that it ain't necessarily so. You know, I spoke one time a year or so ago at a named, chaired lecture to the JAG officers, all majors, about 200 of them, at the Army JAG School in Charlottesville. Many of them, and I talked about these things, and it was not an entirely sympathetic audience. I mean, these were young Army lawyers, and they really hadn't made the turn yet. They were at, the reason they were there was that they were at the point that the Army was trying to get them to think on their own, trying to get them to think strategically and not tactically, see the big picture, look over the horizon, and some of them got it and some of them didn't, quite frankly. But it was very interesting because I left a lot of room for questions, and they started debating back and forth, one side of the room to the other. A lot of them had been in Iraq, a lot of them had been in Afghanistan, and many of them actually had been to both places. And one guy would get up kind of defiantly and say, well, Admiral, I was there, and I know that the Geneva Conventions applied, and I knew exactly what the rules were. And another guy kind of raised his hand and said, well, I was there, and I thought they didn't apply. And we ended up in this debate, back and forth. I just sort of stood back and watched it happen between or among Army majors, lawyers, who were very unclear about what the rules were. And it was their job to teach other people about what the rules were. So that it comes as no surprise to me that a smart, articulate, well-intentioned young guy like Ian Fishback was confused about what the rules were. And that's my point. That's the accountability that we've been talking about. That it has to be made clear. They're in a war zone. They have to have sublime understanding of what the rules are, because with the best possible understanding, it's still difficult. With different situations and different people, and you got bullets whizzing around, bombs going off. You can't leave it to people to try to figure it out for themselves, and that was the problem that Ian Fishback had, and that's the problem that Senator McCain addressed so well. Thank you.
My question is to Julian. If the executive branch has deference, according to what you're saying, and if some of us believe perhaps that there's been criminality involved here, in violations of torture, then would you agree that the executive branch has to recuse itself in all respects from investigating that?
Well, let me just try to be clear. It's not my view that the executive branch. Try this one. It's not my view the executive branch is immune from prosecution. My argument is what I consider to be, maybe not here, but what I consider in general to be actually a middle argument, right? If you take the extreme argument being the executive branch is immune from prosecution, from everything, and the other extreme might be the executive branch is criminal, maybe should be tossed out or impeached. Somewhere in the middle is this idea that they're obviously accountable, in my mind, for violations of the Constitution and for applicable treaties and statutes. My point is that customary international law is the most improper, or at least for doctrinal reasons and sort of functional reasons, the least proper sort of type of law to try to apply against the executive branch.
Yeah, thanks. I was given Dean Hudson's comment that nation states will always do what's in their best interest, whether it really is or not, and that the U.S. is more forwardly deployed than anybody else in the world, and basically the Iraq war is being sold as critical to winning the war on terror. In fact, Mr. Bush was quoted in the LA Times today saying, "We will never back down, never give in, and never accept anything less than complete victory." And somebody else mentioned, I think, on another panel today, that terrorism has actually increased since the start of the Iraq war. And then taking into account Dean Hudson's comments on the goal of terrorists and bringing us down to their level, what is the wisdom of being involved in Iraq at this point?
I think that's to you.
Well,
I mean, this is sort of off the subject, I suppose, and it's just my own personal opinion, obviously. I'm not speaking on behalf of the Franklin Pierce Law Center. Actually, I probably am for about 90% of them. I think it's two things. One is that I think it's a huge mistake, and I think that I feel personally misled. I mean, I'm a registered Republican. I never voted for a Democrat in my life until 2 years ago. It started out as an effort to find weapons of mass destruction. It became an effort to find Saddam, and now it's the global war on terror. And that's Bin Laden, he can run but he can't hide. Oh, yeah? So I think that, we have lost 2,000, almost 2,000 Americans. I've got a student, a wonderful gal, who's a Navy nurse in the reserves, and she spent her last summer, dealing with people coming back on medevac flights. And of course, one of the reasons we've got 2,000 as opposed to 20,000 is because of the wonderful advances in battlefield medicine. But the consequence of that is people are coming home terribly maimed. They would have been dead in Vietnam, but now they're just terribly maimed. And they're kind of the forgotten souls in many respects. And they're people that are going to have a very difficult time with the rest of their lives. They'll be alive, but in only a manner of speaking. So, Powell said, the Powell doctrine was that you only go into war when you've got a clear objective, so that you know when you've won, you know what you're trying to do and whether you've won or not won. You go in with overwhelming force, and you go in with an exit strategy, and you go in with the support of the country and coalition. Those 4 attributes, I think. We're batting like the Red Sox.
Can I just point out that I don't necessarily support the Iraq War in all its forms either, but I would say, and I do think that President Bush obviously takes credit for it, so should get blamed for it as well. But I would say that 70 U.S. senators voted to approve the joint resolution, and a very large majority of the House did as well. And so, look, it wasn't, I think we can call it Bush's war, I suppose, but as a legal matter, you could also say it's the war of that Congress as well. Hillary Clinton's war, perhaps?
I'd like to...
The House of Commons also...
Can we take it one at a time and make sure we wait until we get the microphone, please?
I'd like to follow up that question, or in another sense, turn it into a legal question, which is to say, does the United States have a duty as an invading power, followed as an occupying power, to maintain the safety and security of the country that it has invaded and occupied, and not to leave until a certain stability has been established?
Is that addressed to Dean Hudson?
Legal question.
Well, you know, my feelings about law versus morality, but I think we do. I mean, I think we've got both a moral and a legal obligation, and it's, you know, it is, you know, I guess we're still members of the UN. I think there's lots of reasons and obligations that we have taken upon ourselves, and it's not just the Pottery Barn analogy, but the Pottery Barn analogy works for me as well.
Admiral, I think we can all agree, if nothing else, that whatever restrictions are imposed on torture, that the first line of enforcement is indeed the military and the chain of command. And this has troubled me. You suggested, in a way, that the chain of command has to be held responsible for failures that are discovered at the where the rubber meets the road. I remember reading some years ago that one of the great weaknesses of the Soviet military and of several other militaries historically was the discipline of when something fails or goes wrong anywhere on the chain of command, that they punish the entire chain of command, and that had highly unsatisfactory results. And I'm wondering how you preserve the chain of command while holding it accountable without making the mistake of the Russian military. I should say the Soviet Union military.
Yeah. That is a really insightful question, and it is a very, very difficult problem. You know, the chain of command, and I've never counted it up, but the number of people, or even just the number of pay grades in the chain of command, from the president through, you know, the Secretary of Defense, through the warfighting commanders in chief, to the generals. You know, there's probably 20, at any rate, from top to bottom. Who do you court-martial? Who do you hold responsible? Who do you relieve of command? You can't, as a practical matter, hold everybody equally accountable. So you end up sort of picking and choosing. That's why I got involved, frankly, in the lawsuit against Secretary Rumsfeld. And I specifically argued that we not include as defendants in that case the rest of the chain of command. Although, you know, Sanchez, Bremer wasn't actually in the chain of command, literally, but plus, you know, he's got a Medal of Freedom, so it's hard to, you know, that hurts. It'd be great in the sentencing part, though, wouldn't it? You know, that you'd argue that he had a Medal of Freedom, so you really shouldn't sentence him. For me, it was important that we hold the guy at the top, or the penultimate guy at the top, responsible. And just do it that way. But it applies all you know, in lots of different situations, not just this. You know, the tail hook was a great example of, you know, who do you shoot? You know, in that case, a Secretary of the Navy retired, a Chief of Naval Operations retired, and you know, a bunch of 3 and 2 stars retired, and careers were ended. But, who's responsible when you've got something that big? It's a hard thing. But whatever the answer is, it's not just the few bad apples.
Admiral, I believe you said that the chain of command and the purpose was that what you ended up with the orders going down all the way to the bottom so that they would give a mindless reaction, that they did not have to think. I'm not very intelligent, but I think that and it's my opinion that...
You've probably been a Marine.
Yes. Known as
That's not fair. For all you jarheads, hoorah, semper fi.
I've got mine. You can go. The Nuremberg trial, if I understand what it really did, was it threw on each individual the responsibility to decide whether that command was lawful, and that there would be no, you could not hide behind the mindless following of orders. And if I am correct in that, then I think the chain of command, what we've really done is destroyed the whole military and your argument. Do you have any comments?
No, I think that Nuremberg stands for the proposition that people, and maybe I was being too glib, but Nuremberg stands for the proposition that, in this context, that you can't say I was just following orders. What we want to do is give soldiers, and Nuremberg was, at a different level. We weren't dealing with just the foot soldiers, but we want soldiers and the chain of command to have sufficient confidence in the rightness and the legality of their orders that they are confident following them mindlessly. But, and Milai is an example, if they do that and they're wrong, then they can be held accountable. I'm just saying that we want them to know that their superiors in the chain of command have thought this through and are confident of the legality of what it is they're ordering their troops to do. And that then the troops don't have to spend a lot of time thinking, well, gee, is this legal? Is going through all the rules of engagement, the ROE that they're given. We don't want them to have to worry about, well, this church, this museum, this individual, proportionality. That if we're going to end up killing some civilians, this is not too many civilians given the importance of this particular objective. All of those things, and you don't want the lance corporals to have to worry about that. But what we have seen is that now the lance corporals do have to worry about it because the chain of command can just sort of blithely go through life without ever having been held accountable for what I would suggest are illegal, misbegotten orders.
So do you believe that England's should not have been tried?
No, I think she should have been. I think she should be tried. I think that she was clearly guilty, but her successors are now going to have to question whether the orders that they're given are correct. And I think that is an unfortunate consequence of not holding the chain of command, however you do it, not holding the chain of command accountable.
We have time for a couple more questions.
This is going to be probably the least legalistic comment that has been made today. But last night, just before, very late last night, just before I went to bed, I turned on the television and I just turned on a program, some just some commercial TV program. I don't even know the name of it. But it was a cops show, and I don't know if anybody else had seen this, but it was about 3 young boys, teenagers, early teenagers, 2 of whom had tortured another fellow student at a local high school. And there was a scene in which the torture was reenacted. There was a flashback to the actual torture of this one boy by these 2 other bullies. And I thought about it because I had never really, it was a curiosity to see, even though we've had a lot of violence in our schools, but this little boy was, a young boy was, sat on a folding chair, water was poured on top of him, and then one of his bully friends took a live wire and put it, hit his body with it, hit his wet body with it, and began to electrocute him. And I was amazed to watch it. I mean, I turned on the TV to decompress, but I'm thinking today, if this England girl who just got sentenced and is going to be serving her time is 20 years old, I think, maybe 21. She's 20 years old. She's young. And the concept of torture is infiltrating and pervading our culture. And so, yes, there's a chain of command, but the reason we don't have a chain of command is because I believe that the upper echelons of our entire culture is permitting us to embrace the idea of the violence of torture. And that was just a comment that I wanted to put out there.
Any other questions for the panel? Since I didn't exercise the privilege of asking the first question, let me ask the last if I could. Elisa, you mentioned that you anticipate possibly some congressional action with regard to the Alien Tort Claims Act. Do you have a feel for what might be coming down the pipe?
Well, a little bit, yes. There are a couple of senators, bipartisan, who have growing concerns about the use of the Alien Tort Claims Act against corporations. And there's a big business lobby, a couple of years now, has been, trying to scale back, if not completely eviscerate the use of the Alien Tort Claims Act to reach corporate conduct. There are a number of senators on both sides of the aisle who support the Alien Tort Statute. Senator Specter, chairman of the Senate Judiciary Committee, is one of the leading ones. So it's not a foregone conclusion that any of this will pass by any stretch, but there will be legislation proposed, I think, this term that will try to circumscribe the use of the Alien Tort Statute, at least in corporate cases.
Well, that unfortunately is all we have time for. I'd like to thank our panelists.